Good morning and welcome to the First District Court of Appeals. We have 3 cases to be argued this morning. When I say your case, if the attorneys could please rise, state your name, who you're representing, and your readiness to proceed. The first case is State v. Harris.
Kimberly Burrows here on behalf of appellant Felicia Harris. Paula Adams on behalf of the State of Ohio, ready to proceed.
Okay, thank you. The second case is Mount Pleasant Blacktopping Company, Inc. versus Inverness Group, Inc.
Your Honor, James Houston and Brian O'Connell on behalf of Inverness Group and clients are here with us today, and we are ready to proceed.
Thank you.
Richard Meyer and Joey Kramer on behalf of Mount Pleasant Blacktopping.
Okay, thank you. And finally, we have Adina Gentry versus Silver Linings Agency et al.
Ted Wills representing Adina Gentry, and I'm ready to go.
Thank you.
Ted Capitas, representing Silver Linings. Ready to proceed.
Okay, thank you. I will be using the lights. When you see the yellow light, that means you have about a minute, and the red light means that your time has expired. Ms. Burrows, whenever you're ready, would you like to reserve time?
Yes, Your Honor, I'd like to reserve 2 minutes for rebuttal.
Okay.
Good morning again. My name is Kimberly Burrows here on behalf of Felicia Harris. The only question before the court today is this: should Ms. Harris have received a hearing on her post-conviction petition? The answer to that question is yes. To earn a hearing, Ms. Harris needed to clear 2 hurdles: res judicata and her burden of going forward. Res judicata required her to offer new evidence outside of the record needed to fairly and fully litigate her constitutional claims. And her burden of going forward required her to, with that new evidence, show substantial grounds for relief that are not disproved by the record or the new material. She did both. She produced documentary proof that a speedy trial and due process violation occurred, and that her attorney rendered deficient performance to her prejudice by failing to vindicate those rights.
And the judge's decision was it based solely on the res judicata?
Your Honor, I understood there to be 2 grounds in the trial court's entry: res judicata and what the trial court described as the failure to attach sufficient evidence to the petition. I interpret that to be about the statute's substantial grounds for relief standard.
Okay.
I think under both grounds, the trial court was misguided there.
All right.
And just to pause for a moment on the quality of the trial court's entry. So this court has recently held that trial courts, when denying hearings on post-conviction petitions, need to be pointing to, and it's not just this court, it's also the Supreme Court, pointing to specific parts of the record that create the res judicata bar or give the reason that the record disproves the claims. And this trial court's entry is very minimal and fails to do both. And so just for the deficiency in the entries this court could reverse, I do want to just remind the court and clarify that the relief we're requesting is not just a reversal for a new entry, but for a hearing. The reason for this is the window to afford Ms. Harris meaningful relief is rapidly closing. She's scheduled to be released from her prison term in March of 2025. And so if we needed to litigate this in another round of appeals, we would be able to afford her no meaningful relief. But moving on to the substance of the appeal, again, the 2 grounds that we're disputing here today are res judicata and this substantial grounds for relief standard. Again, my friends on the other side asked the court to apply old law to this case. The Ohio Supreme Court recently clarified in Blanton and Bethel, which were ineffective assistance and Brady cases respectively, that there is no obligation under res judicata for Ms. Harris to show that the evidence she offers now would have been reasonably discoverable with due diligence. That's not a standard that we apply in res judicata in these kinds of cases. And if you look into those cases, it makes sense. The arguments here are Ms. Harris didn't have a competent defense attorney, and she should not be punished for the failings of her defense attorney. So that's not a part of the standard here. The only standard the court should be considering when deciding if res judicata bars a petition is whether Ms. Harris has offered evidence to horse the record outside the record, and the evidence is necessary to fairly and fully litigate the claim. Those words come from Lester. That is exactly what she's attached to this petition, just to give sort of a checklist of the new information that was previously unavailable in this case. Ms. Harris produced for the first time her signed by her, IAD demand executed in Kentucky at the Boone County Jail. She had not previously obtained that paperwork, and she, while incarcerated, did not have the ability to copy it or retain copies herself. She produced proof that the prosecutor in Hamilton County and the court received actual notice of the demand. She also produced strong circumstantial evidence of the approximate date on which both of those entities received that actual notice.
What did she show to show that the court got it?
The only direct evidence that the court received actual notice of her demand is that in the October 1st letter in which the Hamilton County Prosecutor's Office wrote back to Kentucky to request custody of Ms. Harris, there was a certification, this is a form certification by Judge Lubers indicating that Mr. Gibson, I believe is his name, was the proper authority figure in Hamilton County to take custody of Ms. Harris. I do want to pause here and talk about the legal standard. Under the IAD, there is, in the vast majority of ways in which a defendant is required to comply with the statute, the standard is substantial performance. There's one exception, and that's the exception announced in the FEX case. There must be proof of actual delivery. But in Ohio, a recent decision, I believe it's State versus Maury, the court recently reminded courts throughout the state that for every other aspect of compliance with the IAD, the standard is substantial compliance, not strict compliance. And in this case, I would argue to the court that delivery to the prosecutor, actual delivery to the prosecutor, is enough, I would say.
It's enough to inform the court?
Your Honor, I would say that, again, the FEX case is specifically about actual delivery. It's not about which of the two entities must be provided actual notice. And I'd say when you read the case law of FEX and this Ohio precedent on the issue, when it comes to, I don't think there's a strict requirement that defendants provide actual notice to both entities, because in every other respect, aside from actual delivery, the standard is substantial compliance. And so I would say, to put it simply, if a defendant provides actual notice to a court or to a prosecutor, they've substantially complied with the statute. Because what happens is, in daily life, is what happened in this case. One provides notice to the other. Courts, of course, would not keep a ex parte letter like that, from the prosecutor, from the state that has an open file against the person, or an open case number, and vice versa. I think these things would be, both parties have an interest in executing their requirements under the statute, and so I think for those reasons, and for the reasons stated in Ohio precedent, substantial compliance, I think, is satisfied in this case, even if we can't directly prove when the court received actual notice. All we need to prove is when either the court or the prosecutor received actual notice, and I think we've done that here. Again,
Would an evidentiary hearing, sorry.
No, you go ahead.
Would an evidentiary hearing then be able to further shed light on when the state or the court received this notice?
We would certainly hope so. I have no reason to expect the Hamilton County Prosecutor's Office would not keep records of certified mail delivery. I would expect to find those in their files. We were not able to obtain them just through public records without a hearing, which is why we need one now. So yes, I think the answer to that question is yes, we would learn more. But even if for some reason those certified records are missing, the circumstantial evidence attached to the petition is this letter from, including the IAD demand, was mailed on June 10th. The Kentucky jail is 16.7 miles from Hamilton County. I think if you assume the ordinary workings of the United States Postal Service, and we have no reason not to here, that would have taken less than 5 days to travel the 16.7 miles. Any jury could reasonably infer from this information already provided that the most reasonable inference is the letter made it a few days later into the hands of the prosecutor. But yes, I do think at a hearing we would be able to shore that up with direct evidence.
And when can we infer that the letter made it to the judge?
The only strong proof of that, Your Honor, is the October 1st certification.
So it could be that the prosecutor's office didn't inform the judge until October.
It could be, and Ms. Harris should not be punished for that. And that's what Ohio case law indicates, that when the defendant does everything within their power to substantially comply, in the state of Ohio at least, that is sufficient to enforce and vest their IAD speedy trial rights.
If she would have sent a letter to the judge, then maybe things would have gotten moving quicker, right? Instead of
Honor-
waiting for the prosecutor's office to inform the judge.
Your Honor, the IAD requires a certification from the jailer in Kentucky. So it was the Kentucky jailer, Prindle, who made the decision of who to mail a letter to. I do not know if a letter was not mailed to the court. It may have been. The only records that we were able to find without a hearing indicate that the letter made it to the prosecutor's office. But even if a letter never went to the court, again, that would not have been, Ms. Harris needed a certification from the warden in the institution she was in that she could not have obtained and then sent herself to the court. It was the institution that decided who the addressees would be.
So is it your position that once she did her part, when she made the request, after that, it was kind of out of her hands, and it was the warden's responsibility, and that as long as she complied, then that's all that needed to happen?
That's my understanding of Ohio case law. There are many of the IAD fact patterns in the state of Ohio are, raise these difficult issues of incarcerated individual, not just a defendant, but somebody whose liberty is restrained, who doesn't have normal access to the post office, for example. When they do everything within their power to comply, that's why we have this substantial compliance standard. Substantial compliance was the standard in Ohio before FEX. FEX is a federal case law, but within state law, to the extent that these issues are not preempted by federal supremacy, the standard in every aspect of the IAD is substantial compliance to address exactly these kinds of questions. What do we do when a lot of this is out of the defendant's hands, and yet the burden is on the defendant to cause the delivery? That's why we have that standard. Moving on so we've discussed a lot of the sort of procedural aspects of the IAD. Again, the trial court's grounds were res judicata and substantive grounds for relief. It's worth spending some time on the merits here just to show that Ms. Harris did meet her requirements to meet that substantive grounds for relief standard. We've talked a lot about the IAD, but she did raise two other constitutional claims. Her second claim is also an ineffective assistance of counsel claim premised on a constitutional speedy trial violation, so not the IAD. Specifically the Doggett line of cases, which holds that if the state is non-diligent, if it violates a duty of diligence to pursue a filed indictment, having actual notice of a defendant's location, that can be a speedy trial violation, and that can be a speedy trial violation even if the period of delay is less than the normal 1 year we think about in constitutional speedy trial cases. This court has a decision, State versus Sears from 2005, which held that the state's non-diligence was sufficient to sustain a constitutional violation when the delay was 9 months. Here we have a delay of about 6 months before Ms. Harris is finally transported back to Cincinnati. So again, the evidence that we've attached to the petition in this case to support that claim is the correspondence between the Hamilton County Prosecutor's Office and the court and Kentucky, showing that there was a delay of about 3 months from when we believe they received actual notice of her location until when they wrote to confirm receipt of the notice and request transport. And then there's another unexplained delay of 2 months before transport actually happened. And I think it's important to note that transport happened on the very last maybe 2 days of the 180-day speedy trial period. It's definitely within the last 10 days. So I think, I find that suspicious, and I think it's worth exploring in an evidentiary hearing. Again, the third constitutional issue that was raised in Ms. Harris's petition is, as my friend on the other side pointed out, a novel one.
Ms. Burrows, if you would care to save your time for rebuttal, your time has expired.
Actually, I wanted to ask a quick question on, when we're looking for the ineffective assistance of counsel, we're looking for substantive grounds for relief in order to get a hearing. And I see the evidence that you've presented on these, the IAD claim and the speedy trial issue, but don't we also have to look at the prejudice prong?
Yes, sir.
And this is a guilty plea, or I guess it was a no contest plea,
I believe it was a guilty.
or guilty plea. How are we looking at, it's but for the ineffective assistance, she would not have pled guilty? Is that what we're looking at?
Yeah, so I think it's helpful to understand the context in which the standard arose. So the United States Supreme Court cases dealing with this question come from immigration cases. And in those cases, the defendant was facing deportation.
Right.
And their counsel did not advise them of that consequence. And so from that, we have a standard of where we have ineffective assistance of counsel in a guilty plea circumstance. You don't ask whether the defendant would have won the case, won the speedy trial motion, whatever. You ask, from the perspective of the defendant, are the consequences so grave that they might, from their point of view, they might as well pursue all process afforded to them,
Right.
because things would be pretty dire if they didn't. And so it's a little bit of a subjective balancing. And in this case, it's a little bit different because I believe at least Ms. Harris's IAD case, but all the speedy trial claims, these seem like strong claims to me. And I think that if she was not, and the evidence that we've attached to our petition show, she was not properly advised on her odds of success here, and it was really up to her to make the client-based balancing kind of choices about whether one path would have been better for her than the other path, and that's the standard that this court needs to
What is the only thing that you need in order to get a hearing is an affidavit from the defendant saying, I would not have pled guilty if I had received proper advice?
Your Honor, I can't think of another way to show prejudice in a case like this one where the standard is so subjective.
Okay.
I think that if the courts, so we have some case law cited in our brief about how courts should not reject affidavits out of hand lightly. The phrase self-serving affidavit is often used to undermine the value of one, but I'll tell you, my colleagues and I are often at a loss for how we show these elements without them. I'd say that if this court or the trial court were worried about Ms. Harris's credibility, these things are things that should be explored at a hearing. That's where credibility questions are most appropriate. Your Honor, I'm so sorry to go over my time. Thank you.
That was my fault, sorry.
Ms. Adams, I'll give you a few extra minutes if you need it.
Good morning, may it please the court. I'd like to start where Judge Krause asked the question, and I think it is a significant point here. The guilty plea is a significant point, and I think the reason that the trial court's denial of the post-conviction petition that their entry is fine is that, and my friends on the other side have claimed, we're relying on old law. Well, the old law isn't reversed. It's not bad law. It's applicable in this case. In fact, Capper very clearly says that when there's uncontroverted compliance with the requirements of Criminal Rule 11, when accepting a guilty plea, the court, considering a petition for post-conviction relief, has an adequate record to consider that. And this is before the same trial court that accepted the plea. And I think it's significant in this case, the transcript of that plea colloquy has the defendant very unequivocally expressing her satisfaction with her counsel, as well as specific.
In this case, though, if a defendant, the defendant is not supposed to know what the law is, correct? The defendant herself.
Right, she's represented by counsel.
Yes.
Right.
And if counsel does not explain to her this constitutional right to a speedy trial, or under the IAD, the right to the speedy trial, if she doesn't understand that those rights exist and trial counsel didn't tell her about it, what effect does that have?
And again, we have the same during the plea colloquy, and I don't believe that I've ever seen it that specifically mentioned, but in the colloquy pages 19 through 21, the trial court specifically asked her if she understood that she had a right to a speedy trial and if she wanted to waive that. And that was specifically addressed during the plea. And again, I think it's significant that we have no attack whatsoever on the voluntary, knowing, intelligent allegation with regard to accepting the plea, that this is purely being put on defense counsel as being ineffective.
How do
And
you
I think-
address her affidavit that basically says that if she would have received proper advice, she wouldn't have pled guilty?
Right, and what else is she gonna say, right? I mean, that's.
But doesn't that kind of get her, over the hurdle to at least get a hearing for the judge to determine credibility?
I don't think so in this case, because again, the trial court is required to look at the record in addition to what the evidence towards the record. And this was a significant stack that was presented with her petition. And I can't answer the question as far as the timing and that with the IAED, but I don't think it's really necessary to get into the nitty-gritty of that with this case based upon when you see what the trial court was looking at when presented with this petition being the record versus all of the documents that were submitted to the court, and that was not enough to overcome what's provided in the record, and therefore providing a hearing
Ms.
in
Adams?
this case.
I have seen case law where it says that generally when a defendant pleads guilty, they waive their rights to raise speedy trial, but some courts have recognized a potential exception when the speedy trial claim is raised in the context of ineffective assistance of counsel. So if we were to follow that law, what's your response to that?
Well, again, I think the entire record in this case kind of swings the pendulum the other way, if you will, that the information that was before the court, and that's what, the trial court's limited to that information. She has the record versus those documents. And the defendant saying, oh, okay, yes, I wouldn't have pled guilty if I had known this. That, again, what else is she going to say? So I don't think that the court has to necessarily elevate that declaration that she's put forth just because it's in an affidavit before her. It doesn't necessarily negate everything else that the trial court knows about the matter. And again, this was, and we don't have a significant amount of time that transpired between, so quite frankly, this could have been more fresh in the trial courts, not having to necessarily go back and look at all the documentations because.
Well, Ms. Adams, it seems to me that if a defendant is in a situation where there potentially could be a speedy trial violation, which that would mean that the charge would have to be dismissed, why would somebody, if they knew that going in, why would they plead guilty?
And I don't think that it's that cut and dry either.
It's not, for sure.
And again, this record, this is the defendant herself appearing before the court asking to be able to go over to Kentucky to face a probation violation over there. So this wasn't something new where she, they're in the middle of plea negotiations or something going on with the case and she just takes off. She asked the court to go over to Kentucky to take care of the probation violation that obviously, unbeknownst to her, they decide, no, we're not reinstating probation, and they locked her up. And that's kind of what sets forth. But another interesting matter, and again, I don't think it's necessary for this court to get into the nitty-gritty of all the IAD stuff, but I noticed in that paperwork, there's also an IAD for the state of Indiana. So I have no idea how that factors into this, but certainly a lot of unnecessary documents were placed or were attached to that petition. But again, I don't think that just because of the mere volume that was presented to the court was enough to overcome what the trial court knew based on the record and to grant a hearing. So we would ask that it be affirmed.
Let me ask you a question. You mentioned that the trial court seemed to spend an inordinate amount of time discussing her speedy trial rights. And I don't recall from the transcript, I understand what you're saying, but I don't recall from the transcript whether the trial court acknowledge that there was that IAD in the record somewhere? Or was that discussed at all?
I don't believe, again, I noted pages 19 to 21, but I don't think anything specific with regard to the IAD at that time. But again, there was information presented to the court early in the process of this case that she had matters in Kentucky. At
Nobody
least.
brought it up, though, during the plea
Right,
colloquy?
right.
Okay, all right.
And the race judicata, I mean, would you agree that all of this evidence is outside the record as far as the IAD information? Because none of that was presented to the trial
Right, and
court previously.
yeah, honestly, I was surprised that that doesn't get filed.
Yeah.
It's not docketed as far as I could tell, but I don't always have access to everything either. It's sometimes shocking what we don't have access to. So certainly that would have been evidence to horse the record, but again, I don't think it's enough to overcome what the trial court had in the record
Okay.
to grant the hearing. I don't think that it was,
So you think it's
arose
race
to that
judicata?
level.
That there's a race judicata bar, or no?
I think, and again, I think based on what the trial court put in her entry, it was both race judicata, what's in the record, versus what was attached that wasn't sufficient.
Right, right. She had two
Right.
different grounds.
Correct.
But do you agree with her race judicata ground?
I do, in this
Okay.
case, yes. Thank you.
Thank you. Okay, Ms. Burrows, you have 2 minutes.
I'd just like to respond to a few of the points my colleague made. Again, thank you, Your Honor, for the 2 minutes. Let's work backwards. So first, starting with the question of race judicata, my colleague asserted that although this evidence attached to the petition is to horse the original record, it's not enough to overcome what is in the original record. It's frankly hard for me to wrap my mind around that line of argument because there is almost nothing in the original record regarding speedy trial, the IAD, so on and so forth. I think that on race judicata, this is not a closed case. This is all new material with key documents directly relevant to the claims.
So you're focusing on whether you presented substantive grounds for relief to get...
Right now, I'm responding to the issue of race judicata.
No,
I
but
think-
like the focus, you're saying yes, or
Oh,
it's
sorry,
not
yes.
race judicata, so we need to look at the second reason why the judge denied.
I think if there is a closer issue in this case, that is one of them. That is
Okay.
probably the one that's a closer issue. But again, Your Honors, I think that the standards on meriting a hearing have recently been clarified, and this is a petition that merits a hearing. Regarding the unnecessary documents, just to clarify, I did file the petition below in the trial court. If you look at the index describing all of the exhibits attached, hopefully it's clear that each letter in the exhibit was the source of the public records request. So there's an exhibit of everything obtained from the sheriff's office, everything obtained from the prosecutor's office, everything obtained from the jail in Kentucky. And again, that is basically the entire investigation that we did in this case, and I hope that the takeaway from this court on that is not that there's unnecessary documentation, but that there is nothing further that Ms. Harris can do to vindicate these rights without a hearing and without court-compelled discovery.
Your time has expired.
Thank you, Your Honor.
Thank you. Okay, this case has now been submitted, and we will issue a timely decision. Our next case up is the Mount Pleasant Blacktopping Company versus Inverness Group, Inc.
Your Honor, may I ask perhaps a naive question? The lights that you were referencing, the ones on the podium,
Yes.
I just want to make sure where I'm looking.
Mr. Houston, you're arguing, correct?
Yes, ma'am.
Would you like to reserve any time?
5 minutes for rebuttal.
Okay. Whenever you're ready.
Good morning, Your Honors. May it please the Court, James Houston on behalf of Inverness Group. Inverness contracted to have Mount Pleasant Blacktopping deliver and obtain governmental approval for 24 lots on which my client would develop and sell residential homes. We paid over $600,000 in contract funds and held retainage for that to be accomplished. Unfortunately, Mount Pleasant delivered only 19 serviceable lots of the 24, so there are 5 lots as it stands right now that are the functional equivalent of paperweights. We can't do anything with them. The parties allocated the risk of this precise failure within their contract. Mount Pleasant took the risk that government approval would not be obtained, and it did so with its eyes wide open. At trial, Mount Pleasant witnesses, including Principal Ben House, testified that it was common knowledge in the construction industry and that they individually subjectively knew that regulatory interpretation can change when administrations change, as happened here. We had a new sewer director.
But let me ask you this, the
Yeah.
regulation itself didn't change, correct?
The regulation ultimately, the regulation that was applied here ultimately was superseded, but the regulation that was interpreted both by the federal court and the state court was identical.
Okay.
Thus the grounds that we've raised of issue preclusion here in this case. So from our perspective, beyond the issue preclusion, which I'll address in a moment, there's a fundamental bedrock principle of commercial law, and I as a construction lawyer rely on it daily when I negotiate contracts, is the principle set forth in the Dugan and Meyer Shook case, which is parties must be able to allocate risk in their contract. They're freely able to do so, and courts will not bail out parties who have buyer's remorse over contract provisions that they found post hoc were things they shouldn't have or didn't want to agree to. And then secondarily, I'm sure we'll talk more about the security sewage case today, but if you look not at the dicta, but the actual holding of the case, which is in paragraph 2 of the syllabus, and as you all well know, the law of the case, which is binding on this court, is found in the syllabus. The court held that when a party undertakes the risk to obtain governmental approval and doesn't, the risk is on them. You break it, you buy it.
So you're arguing for absolutely no exception to that, right?
No, not at all, Judge.
Okay.
As it relates to my client, there's no exception with regard to the respect that we allocated that risk. The time to negotiate for an exception was before pen hit paper on the contract. And I will tell you, when you negotiate these types of provisions, for example, there's often instances where a general contractor will be told by the owner that it's going to provide a list of subcontractors, and the owner's going to have to be able to approve those subcontractors. And you know what language we include? Such approval will not be unreasonably withheld. If you're going to preserve the viability and ultimately the predictability and certainty that is provided by the Shook and security sewage cases with regard to the freedom of negotiation, you have to place the risk allocation at the front.
So are you saying that the contract in this case encompassed, they had to get government approval, and it could be even unforeseeable, arbitrary reasons? It encompassed everything?
I'll answer that in 2 ways. Yes, to answer the question directly.
Because they didn't put specific language in there.
Because they assume the risk.
They assume the risk that somehow this person could just make up a reason that was never applied in prior cases, which seems to might have maybe happened here.
Yeah, respectfully, with regard to my client, the exception is a matter of contract law.
Right.
So there is no exception, and that exception could have been bargained for. They did have the opportunity, based on that allegedly irrational conduct, which it wasn't from our perspective, to pursue their rights and remedies against Greene County, which they did, and they did in federal court. And the issue of whether that decision was erroneous, arbitrary, capricious was fully litigated. And just turning to that issue, as the court well knows, issue preclusion is a principle that applies to avoid a situation. The whole purpose is to prevent a situation where 2 courts pass on the same issue and then reach diametrically opposite results, which is exactly what happened here.
Isn't it a little bit different? I mean, the standard that the federal court was looking at was under a due process violation, and it seems like in the federal court, it was looking a lot more narrowly at the issue.
Yeah, respectfully, again, I'll sound like a broken record here, but I'm going to rely on Supreme Court law yet again. If you look at the Fort Fry decision, it's 81 Ohio State 3rd at page 396. The Ohio Supreme Court stated where federal and state law standards, which was your point, Judge, where federal and state law standards revolve around the same factual issues, issue preclusion still applies. So you can have different state and federal law standards. Binding precedent examines whether the same facts and same evidence would sustain both issues. And that's, again, that law is legion with regard to how you determine whether the issue is the same or not. And what the courts require us all to do is you look at the evidence that was presented. Case law holds where the same evidence would provide the underlying facts for both proceedings, the issues are the same, and issue preclusion applies. Well, what was the evidence that was submitted in federal court? It was a comparative analysis between lines, sewer lines that had been approved by Greene County in prior instances, and this particular sewer lines at issue here that had been rejected. The evidence that was submitted was the same evidence that was submitted in this case. You had affidavits of the same witnesses, and I know because we litigated both of these cases, it was the same witnesses, including expert testimony, and also included screen captures or portions of comparative illustrative analysis of lines that were approved and lines that were not approved. And the federal court determined that, again, in its verbiage, Greene County has not acted in an arbitrary or capricious manner in rejecting the lines.
And it did so this has happened to us before. I don't know what's going on with our
I
microphone.
feel like I'm at McDonald's and I should push it.
I know. It did so when it was trying to determine whether there was a rational basis for the decision, right?
It did.
I mean,
but-
that was the context of whether it was arbitrary and capricious.
Correct, but the issue that was being litigated, which are the same two issues, the same principal issues that are involved here, is whether Greene County complied with its own regulations and whether it acted arbitrarily. And again, as I stated before, whether the issues are identical, or the legal principles, the standards that are applicable to those issues are different, issue preclusion will still apply if the facts that are supporting those issues are the same, which they were in this case.
And then in the state court case where the judge is talking about the interpretation of the regulations being arbitrary and capricious, the judge is really referring to whether or not it was foreseeable that they would be interpreted in that manner, right?
Well, yeah, what he did, 2 points to that. One, factually, he's simply wrong, because if you look at the contract itself, there were 12 different ways that we allocated that risk. When you allocate a risk that you are taking the responsibility to obtain approval, it's implicit that approval might not be given. So to argue that it's unforeseeable is simply wrong. Secondly, what the judge did with regard to this proposed exception or purported exception is he kind of do not pass go, do not collect $200. He passed paragraph 2 of the syllabus and went straight to dicta. And he took a UCC case involving the sale of goods and applied effectively an impossible, unforeseeable exception that has no bearing on this case at all.
Have other courts applied it?
Not to my knowledge. There are cases that have been cited by opposing counsel where there's no Jones versus Smith case where the exact principle is applied and articulated and found to be superseding of the syllabus. And the cases that have been cited are cases where the risk of acceptance or approval were not allocated through contract, which is the case that we have here. And I will tell you that being a practitioner in this area of the law, again, as I mentioned before, predictability and certainty are critically important. And the concern that I have is if this so-called phantom exception is acknowledged by the court and we have an opinion which effectively adopts it, from my perspective, erodes 2 Supreme Court opinions, you're going to really unwind the knot here on the way construction contracts are negotiated and interpreted in Ohio, because the instances where contractors have to obtain approval in a construction project are legion. If you've seen the divisions in a construction contract and the specifications, they're like this. You have framing, you have foundation, you have electrical, you have MEP. There are inspections for all of that. And if you accept Mount Pleasant's position, my MEP goes out and tries to get their approval for the mechanical and electrical. It's denied. I hold up my contract, which has 12 different areas where they took that risk, and I say, hey, we allocated this risk, and they say, sorry, Johnny Yubyuch is the inspector, and boy, he's just nuts. So good luck with your 2506 appeal.
Can you tell me again what language you typically put in a contract in order to allocate the risk that you might have somebody say, oh, well, the sky is, red today, so I'm going to deny your.
Yeah, just the one I mentioned to you earlier, Judge Krause, that what is typical is you say, we will obtain approval, such approval not to be unreasonably withheld. And then we at least have a fighting chance of ourselves allocating a risk. If Johnny Upjudge does go nuts, we may have to litigate this.
Okay.
We didn't do that here because my client's not bargaining as much as I'd love to charge him by the hour. He's not inserting contract provisions to allow me to go do 300 2506 appeals or to negotiate in federal or state court about whether this one, how many inspections are there? This contract would be rendered meaningless in allocating that risk if every single time a contractor would be able, or subcontractor would be able to say, well, this was just an unreasonable, unforeseeable result. And unfortunately, unforeseeable and unreasonable are amorphous and vague standards, and I think what will happen is, if you all recall the intentional tort law, you had a statutory regime, where you had workers' comp that was supposed to allocate the risk of injuries to employees, and then you had intentional tort law, where you had a vague standard about foreseeability of an injury, likelihood of injury to an employee. And what did you have before the General Assembly stepped in? Every single time there was a serious injury, you had two cases. You had this workers' comp case, and you had the companion state law case, and that will happen here. And what's even worse is the way that the judge in this case interpreted the security sewage case is you don't even have to be in the same county. You could be in Tuscarawas County and then file a lawsuit in Cuyahoga and say Johnny Upjudge in Tuscarawas doesn't know what he's doing.
Mr. Houston, I'm actually going to give you a little bit more time, and I will afford the same thing to your opponents. That brings up a question here. What happened to the declaratory judgment claims? Were they ever dismissed? Are they still floating out there?
I'll tell you what I tell my 5-year-old. I don't know.
They weren't resolved.
They weren't, and the judge, from my perspective, with all due respect, I think he did his best to be fair and interpret the record. I enjoyed trying the case in front of him. I have nothing but high respect and regard, but he missed a lot of legal issues. And I
Do
think
we
that's
have
one of them.
jurisdiction?
We do raise the issue of the failure to join Mount Pleasant blacktopping. It is an issue, and it's a jurisdictional issue. And I don't believe he resolved that claim. I don't see it in the opinion. He seems to implicitly have done so when he interpreted the regulations and provided an interpretation that was contrary to what we argued. So I think the court would be within its rights to determine that that issue has been resolved. Our preference, frankly, because of the numerous errors of law from our perspective that occurred, is that we don't want to try this case for a third time. We believe that this case should be resolved on strictly legal principles, and there are two bedrock principles that have been overturned on the strength of quote-unquote dicta, which is precisely what I was taught 30 years ago, 25 years ago. It doesn't happen. The law of the case is in the syllabus. If the judge simply would have applied the syllabus, he would have gotten the right result. And beyond that, again, not taking swipes at him, but the concept of issue preclusion is not new or unique. He kept arguing about or articulating that he was a court of separate jurisdiction, which we didn't dispute at all.
Well, I'm just going to focus you in, though. I mean, being that those declaratory action claims are still out there, they have not been resolved, they were not dismissed. Is this a final appealable order?
I believe it is, Judge. I believe it is because my position is that he didn't articulate it specifically in the ruling, but I do believe he resolved it implicitly. And again, from our client's perspective, there are significant enough legal errors that this case should be reversed and remanded based on both issue preclusion and the binding Supreme Court law with regard to contract interpretation, and a judgment should be entered in our client's favor. And the only thing we should be arguing when we get down to appeal is what my client's damages are.
Thank you.
Thank you.
Okay, and like I said, I will give you extra time to discuss the
Thank you, I
jurisdictional
appreciate that.
issues.
Thank you. The dilemma that Mr. Houston poses has been solved by the courts and by the statute, where a contract allocates approval responsibility to a third party. there are two exceptions, one by case law, one by statute. And the one by case law, this court recognized about 12 years ago and said there are 4 exceptions. One of them is security sewage, the other is arbitrary, the other is waiver and estoppel, and the fourth one, I can't remember. But anyway, there are 4 exceptions to that rule. So it's not an across the board, if you've got an allocation of risk, you're stuck with an arbitrary decision by a third-party reviewer. You're not in Ohio. Secondly, the statutes addressed this very question, and so did Judge Wagner. Judge Wagner said they waived their right to file an appeal under the statute for an arbitrary order by an administrative agency. They had a remedy. They waived it once when Randy Gilbert, the Greene County guy, their star witness, when he sent a letter first rejecting these 2 spans, they had 30 days to appeal under 2506.
Could your client have appealed? Or was it on them to do that, or could your client also
No,
have done it?
We cited case law and state court. We haven't cited it here. They are the developer. They're the holder of the permit. They're the party that has to bring that action. They waived it twice. And this gets into the facts a little bit, but we did have a 4-day trial. 2 spans were rejected initially because of these low spots. They call them sags, bellies, whatever you want to call them, indicated by standing water and a line on TV inspection. Basic facts. The first time, and by the way, we hired an expert that said those low spots are going to go away over time. Well, guess what? They did. Greene County went back, re-inspected, absolutely no spots, no low spots whatsoever in one span, 1 spot left in the other span. The scientific principle, I know you don't want to hear it. They call it load lag. This pipe is existing 20 feet underground, huge amount of weight, uneven weight, but the weight evens out over time. This is flexible plastic pipe, PVC pipe. It's kind of a revolution in underground piping because the old clay pipes were just a mess. They were always clogging up. These pipes don't. They have a slick surface, they have a low coefficient of friction, and they have a very low self-cleansing velocity. So these PVC pipes are not a problem. Is it just me saying it? No. We subpoenaed the records of Greene County for years. Since they started using PVC pipes, not one maintenance issue with PVC pipes. What did the federal court think about that? That's irrelevant. Means nothing. Because they've got a different, very narrow standard of what constitutes a constitutional violation. If there's any rational basis in federal, any rational basis, it doesn't have to be related to facts. As long as it's related to public health, administrative agency can say anything it wants to say. End of case. And that's important to say because in this case, they're raising the issue of issue preclusion. There's no issue preclusion. Number one, you just heard that the federal court interpreted this regulation, the standing water regulation. Judge Newman in federal court specifically said, I am not deciding that issue. But you're hearing today, oh, the federal court decided that issue already. Secondly, the federal court was very specific about what evidence was relevant or not relevant. You heard about the videos and the screenshots. That was the essence of our case. We took an entire day in the trial of this case to go through, for the past, since 2015, 10 years of videos that showed dozens and dozens of these pipes throughout Greene County recently developed subdivisions. They all had standing water. Why? Because PVC is a flexible pipe. You put 20 feet of dirt on it, it's going to get uneven ripples in the PVC, which eventually they even out. It's not a problem. Their own people, 2 of them testified, it's not a problem. Their engineer testified, it's not a problem. We developed all the facts necessary for Inverness to exercise its statutory right to file an appeal of an arbitrary government action. Now, the issue which it's already been raised, what's the difference between the federal standard of arbitrary and the state standard? And it's an extreme difference. But let me revert to Fort Fry, because Fort Fry dealt exactly with this issue. They dealt with a different standard under the Unfair Labor Practice Act and the Civil Rights Act. And how did they resolve it? What facts will sustain those issues? If the facts that sustain those claims are the same, then it's an identical issue, and it's subject to issue preclusion. In this case, the federal court didn't accept any of our evidence, none. Twice they say there is absolutely no evidence presented by Mount Pleasant of a federal constitutional violation. The evidence is completely different. Our evidence will not sustain a federal cause of action. Our evidence, as Judge Wagner found, will sustain a state cause of action.
So on your regulatory impossibility defense, what all did you have to show in order to meet that defense?
Now,
I mean, I know
I
foreseeability.
I understand the question. We really didn't do it in terms of impossibility. We could have.
Okay.
Because the same case law that talks about impossibility and impracticability
Yeah.
also talks about unforeseen, unforeseeable intervening events, okay?
And that
where
was
the
your
secu-
focus.
That was our focus.
Was
just
the
to say it was unforeseen and unusual.
But what about the idea of whether it was impracticable for you, for your company to fix the line? I mean, I didn't see any finding by the judge on that issue,
No,
or evidence.
Right, we didn't do it under that standard. We did it strictly under the standard of unforeseen and unforeseeable, by the way. One's subjective, one's objective, and unusual. The foreseeability or lack of foreseeability is the same standard in cases dealing with impracticability, impossibility, and arbitrary decisions by third-party reviewers.
But those are two different things, right? The foreseeability and impracticability are two different things, right?
Well, when you say that it's impractical to meet a standard, it doesn't quite fit here. The perfect fit is unforeseeability. And unforeseeability is a consideration in the impracticability cases. Just the word impractical, I mean, doesn't quite fit the facts. Unforeseen and unusual does. And you're being told that is dictum only. It is not dictum. This court in Northside Bank, not too long ago, looked at that standard, the exception under McFerrin, and decided the case. Now, in that case, the supervening event was foreseeable, so the exception didn't apply, but the case was decided under the McFerrin exception. And by the way, it wasn't a UCC case. And guess what? Neither is security sewage. Let's go to the basics. The contract in this case and the contract in security sewage, they're almost the same. They were both for the sale, fabrication, sale, and delivery of a sewage plant versus a sewage underground system. So, they're the same kind of contracts. Let's not, let's stick with basics here. Secondly, there was no specific allocation of risk in security sewage. No specific allocation of risk.
Was the language
So
similar?
they had to conclude that the seller assumed the risk because he said, hey, we'll deliver a product that operates, okay? The same thing occurred in one of our favorite cases, Benjay. The Benjay case is a little different fact scenario. It involves an outdoor concert, but the owner of the concert venue says, hey, we're going to get you this permit for an outside concert. And it didn't happen. And the court said, well, wait a minute here. You've never denied one before. This applicant is being blindsided by this denial. So Benjay applied the security sewage exception. And their objection to it was, well, it was silent on the allocation of risk issue. So was security sewage silent on the issue. It had to be inferred from other language in that contract. So next, is it just dicta? It is not dicta. And there's this brilliant hidden gem case from this court decided, I think this year. It was a restitution case, $3,000 restitution case that had 3 restitution hearings and at least 1 appeal in this court. And the issue was whether the defendant could require the owner of this damaged vehicle to appear in court and be subject to cross-examination. What's really neat about the decision is the court didn't say, oh yeah, there's always a right to subpoena the owner in a restitution case. It didn't go that far. It said, let's look at it as a due process case because due process is flexible. So the court held that when the testimony and evidence is exclusively within the control of the owner of the property, as it was in that case, due process requires that the defendant be allowed to subpoena the person and subject them to cross-examination at the restitution hearing. A neat little case. The dissent said, and this is what they rely on, and so do we got no problem with this. The dissent said, no, wait a minute, that due process issue, that's dicta. That's not the holding in this case. It's only, you know what the dissent said? The dissent said, if the 2 issues are connected, they're not separate and distinct, then there's no dicta. So the dissent cited the right proposition of law, the one they're citing, the one we're relying on, but applied it wrong. It applied it wrong. The majority got it right. The due process issue was connected to the damages issue. So there's only one issue, no separate and distinct issues, therefore no dicta. Same thing here. In security sewage, the court had to decide, because remember, the Court of Appeals ruled in favor of the seller security sewage. So the Supreme Court reversed it. And they reversed it on the basis of a general rule. The promisor is liable to get third-party approval, except. And that exception, the court held, did not apply to security sewage because they had superior knowledge. It wasn't unforeseen or unique that a permit would be denied by the Department of Health where the proponent, the sponsor of the sewage treatment plant, is purely private. It's not in a connection with a public organization. So there was one issue in security sewage, a general rule and an exception, and they were both applied by the Supreme Court. So this is not dicta.
Let me ask you, sir, was there any acknowledgement from anybody related to Greene County that these SAGs over time will even out? Because apparently that's happened, and there's one SAG or...
They came back 2 years later and re-videoed it, and they
approved
saw
it.
all the SAGs were gone in one line, so they accepted that line. Okay, so they accepted that line. The other line, getting into the weeds here, there was one SAG left in the other line. It was right adjacent to the manhole, and that had nothing to do with the load lag process. So the way we handled that was to show videos, 20 videos, where Greene County accepted lines with this spot next to the manhole. The manhole weighs so much more than the pipe does. Therefore, it creates a little low spot of its own. That's not going to go away. It's right there. But it's never been a reason in the history of Greene County, it's never been a reason to reject a line. We showed 20 separate videos, same condition, accepted by Greene County.
Will they ever provide an explanation why, if they know that over time those sags even out, why they rejected this particular project?
Well, why they did, I think it's pretty evident from the facts, and Judge Wagner pointed it out. New man in town, new sheriff in town. I'm setting a new standard.
Right.
Okay, that's what it was all about, a new guy in town. Okay, it wasn't the maintenance records, it wasn't the previous 10-year history of accepting lines with sags. It was a new guy in town saying, they got it all wrong.
But just so I'm understanding, you're saying that all you had to show was unforeseeability in order to be excused from performing the contract. That's the only thing. You did not have to
Unforeseeable
show,
and unusual.
okay,
One time only.
unseen and unforeseen and unusual. You did not have to demonstrate that it would be impracticable to fix the problem, is what you're saying.
We can call it impractical. When this court said there was 4 different theories for approaching the issue of third-party approval, all 4 of them basically have the same kind of facts, except the last one, which where the promisor creates his own problem by interfering with the approval process. The other 3, they really boil down to foreseeability. And I keep stressing it, and I'm going to continue to stress it, foreseeability is the law across the whole area of contract law. It's not limited to the UCC. It's also part of the restatement of contracts accepted time and again by this court, including under the impracticability case law, the restatement case law 261, I believe.
Because it just seems like to me it would be another logical thing. You'd have to show, okay, I didn't expect that they would reject my work, but also it is completely impracticable for me to be able to fix the problem in order to get excused from the contract.
That's not part of security sewage, the impracticability of fixing it, although.
I mean, it is, but it
could have
is
been
part
argued.
of considerations in other courts
Right.
when determining whether to excuse performance from a contract, right? And I didn't see any evidence on that. I didn't see any findings on that from the court. And I'm just asking if that is something that the court should have looked at.
No, we look strictly at the unforeseeability and the unusual. And on the unusual, had never happened before. And by the way, it's not going to happen again under this regulation. Because guess what? Randy Gilbert, not only did he enforce a new policy for the first time in this case, he got him to change the regulation to suit his approach. They did away with Section 398, the one that the provision that Judge Wagner construes in this case. Okay?
Mr. Myers, your time has expired, but I'm going to give you a little bit of time to talk about the claims that were your declaratory claims. First of all, do you agree that the court did not dispose of those claims?
The federal court did not.
No,
Absolutely.
not the federal court, in the trial court here.
Absolutely, he did.
He
Page
disposed
3 of
them.
his opinion gives a long discussion of exactly what we asked for, the proper interpretation of 3.9.8. That's what we asked for, that's what we got.
So he implicitly decided the declaratory judgment claims that you raised. I mean, he didn't
No,
express.
he didn't use the words
He did-
declaratory
right.
judgment, he construed the regulation. Yeah.
But there was no explicit disposing of those claims.
He ruled on what the interpretation of the statute was. That's what he said. And he said we complied with it, which was the basis for him saying that Mount Pleasant substantially performed the contract. We substantially conformed because that sewer line, those 2 spans, are in conformity with the regulations as properly construed. Now, I gotta add this. When I say properly construed, it's as construed by Greene County for 20 years. Okay? That's all we asked for. Treat us the same as everybody else. You know where that got us in federal court? Nowhere. Can you believe it? Anyway, I do have to say that because the other side is claiming that Greene County was a necessary party, their argument is that we challenged the validity of the ordinance. No way. We never challenged the validity of the ordinance. We were willing to live or die by that ordinance. We didn't challenge the validity, which is the Declaratory Judgment Act says that if a party challenges the validity of an ordinance, then the public body needs to be made a party. That is totally inapplicable.
Okay, your time has expired. Thank you.
Thank you very much. Sorry for the science.
You have 5 minutes. I gave both sides extra time to discuss the jurisdictional issue.
Fair enough, thank you. Just a couple brief points by way of rebuttal. First, to the question that Judge Krause asked with regard to impracticability or impossibility. The first point I'd make is impractical or impossible doesn't mean expensive. They don't want to do this because it's expensive. And they did argue repeatedly in the court below and here in their briefing that foreseeability was inextricably intertwined with impossibility. Reading from their own brief, they say foreseeability, that is, where a non-occurrence of governmental rejection was a basic assumption of the agreement, is also a key element under the restatement section 264 when impossibility of performance is attributed to government conduct, as is the case at hand here. MPB then specifically cited Glickman v. Coakley and said, absent contrary contractual terms, either party can often avoid an agreement where government activities render its performance impossible or illegal. That didn't happen here. It's not impossible. They could go out tomorrow and fix this.
Well, I didn't see really any evidence of how much it would cost below.
We
Was
did.
there?
We had an expert come in and talk about what our damages were, and our damages were specifically related to digging up and replacing the one line that remains defective.
Okay.
So it's in the record. I can't cite it to you.
Okay.
There are many things I was prepared to talk about.
Yeah,
today. That's not one of them.
No, yeah, so that was my question of whether the judge made any kind of, or should have made any finding on the impracticability.
I don't think he did, Your Honor, because he focused instead on impracticability, and as my colleague just said, focused on the issue of substantial compliance. Again, we think the law falls in our favor on that subject because substantial performance or compliance with the contract only applies where the deviations are nominal, trifling, technical, or slight. They do not apply when the noncompliance effectively destroys the value or purpose of the contract, which is what happened here. So there's no way rationally that a high school mock trial student could read our contract and look at the 12 different ways that we asked or demanded that they provide approval for these sewer lines, acknowledge what was held by the federal court, which is the truth, and they, I think, even acknowledged they didn't meet the standard, and labeled that fundamental negotiated premise as something that was nominal or trite. It wasn't. It went to the central point of our contract. Judge Winkler asked a question, which I'd like to respond to briefly, which was, did Greene County acknowledge that these lines might settle or even out over time? Kind of two responses to that. One, as Mr. Meyer said, the one line that is still defective, where we have 5 lots that we can't use, will not get better, and their own expert, John Huell, admitted that. Secondly, the evaluation of whether Greene County acted appropriately, it should be evaluated at the time the inspection occurs, not 7, not 8, not 9, not 12 months later, because again, practically from a perspective viewpoint, you'd never be able to hold anybody to their contractual requirement to gain approval because my MEP or electrical or somebody would say, that always happens, just give it 6 months and it'll be right as rain. You have to evaluate what Greene County did at the time of the rejection. At the time of the rejection of both lines, they didn't meet the standard. A couple other brief points, and I'll conclude my remarks.
You have about a minute and a half.
Yeah, so the concept that was argued implicitly here a moment ago by my esteemed colleague, and also explicitly in the briefs, was that the federal court in some way didn't consider evidence or didn't evaluate the applicable regulations at all. I'd remind the court that they actually got the benefit of all inferences at the summary judgment stage. So all of the value was, all of the evidence that was supplied in this case was also supplied in the federal case, and they got an extra thumb on the scale, as it were, because the court construed everything in their favor and still found they didn't meet the standard. And if practically speaking, the court, I should say, actually speaking, the court did, in fact, the federal court did construe the particular provisions that are at issue here. If you look at page 3 of the judge's opinion, the federal court's opinion, he specifically talks both about sections 3.8 and 3.98, which is the specific standard. And Mount Pleasant, throughout the trial, argued that they should really get an actual or true or better or good construction. That was implicit acknowledgement that there already had been a construction, and they ultimately have argued that the federal court's construction was phony. So the statute was construed. Last thing, this idea that the federal court somehow said, hey, we didn't look at the regulations at all, free and clear on, on your state law claims. They're conflating the concept of claim preclusion and issue preclusion. They asked for a clarifying order to determine whether issue or claim preclusion applied, and the federal court did the benign, absolutely appropriate thing of saying, look, I'm declining jurisdiction over your state law claims. I'm not going to tell you what facts or evidence or standards apply to your state law claims. Go have at it. He didn't provide, as they suggest, some sort of advisory opinion that should have guided Judge Wagner or this court. And for the reason, go ahead.
I just had a question on, so your focus clearly is on issue preclusion, that the federal court already decided this. But you're not challenging the factual determination made by the trial court about the foreseeability of this regulation, right?
Oh, absolutely we are, because they acknowledged two key points factually. One, their own witnesses acknowledged that it is foreseeable that standards will change when a regime within a governmental department changes, which is what happened here. And they all acknowledged to a man, as did our witnesses, that standards will vary from witness to witness. So any rational person who spent more than 5 minutes in the field knows that it is possible that from one department to another, from one regime to another, from one inspector to another, the standard will change. That you might not get the same result.
You're saying you're in addition to your legal issues, you've also challenged the trial court's factual determination?
I do, Judge, but I think that he never should have reached it, because that was already determined as a matter of law.
Right. I mean, I know that's your argument, but
Yes.
alternatively, have you challenged the judge's factual determination?
We made, I don't believe we raised that as a discrete matter of error. I raised it with you all just to provide some context as to what's happened here.
Right.
And I'll leave you with the reality is that when you all issue, as you know, when this honorable court issues rulings, they have prospective application. And people are going to look to these cases to determine how to undertake their activities moving forward. And if this so-called exception in security sewage, which rests on absolute straw, is used to supervene two Supreme Court cases, this court will unintentionally upend the way that construction contracts are negotiated, evaluated, and litigated. And the proverbial floodgates of litigation will open.
Thank you.
Thanks.
This case has now been submitted, and we will issue a timely decision.
Thank you.
Okay. Our final case for today is Gentry versus Silver Linings Agency et al. Okay, Mr. Wills, would you like to reserve any time?
Yeah, 5 minutes.
Okay. Whenever you are ready, you may get started.
Okay, may it please the court, my name is Ted Wills, and I represent the appellant, in this case, Andina Gentry. What I'd like to do is start, of course, with the first assignment of error, which is the 2307.60 civil case based on the criminal violation of witness intimidation. In this case, for the plaintiff to prevail on this claim, she would have to prove, one, that she was a witness to incidents of abuse and neglect, and that she was intimidated. She was intimidated by reason of her being a witness to abuse and neglect, and that she was injured by that intimidation. In this case, she was a witness to abuse and neglect. First of all, she was, an employee at the Silver Linings, and she saw first that there was a lack of food for the residents. This is supported by, first of all, the revised code, which states out that abuse and neglect amounts to lack of parental control or parental care, and then also in substantial risk of health or safety.
What was the, I'm sorry.
Yeah, go ahead.
It's probably the same question.
Yes.
What was the specific, maybe not, evidence in the record regarding the lack of food?
Well, we had affidavits by several of the co-workers. Carly Asher testified that the residents had to survive on bread, peanut butter, cheese, and canned goods, that there were locks on their fridge and cameras in the kitchen to keep the residents from getting food. Brandy Oldham said that the children only got like one bowl of cereal, a sandwich, chips or milk or juice. The defendant's response was that the kids are too big. When the employees complained about the lack of food, or the residents complained about the lack of food, the defendants said that the residents were too big, they needed to go on diets, that they didn't need more food. Shamel Parker also filed an affidavit saying there was not enough meat and cheese for sandwiches. And the response to that was that the residents needed to go on diets. And then Ariana Weaver said that the residents were always hungry, and there was not adequate care regarding food. That goes directly to the statute to provide adequate care for food.
Which statute are you talking about?
That is, let's see here. Get my glasses out. That would be 2151.
But that's not a criminal statute. That's a statute used in the juvenile court system for parental termination and abuse, dependence, neglect cases within the juvenile system, and that's civil.
Well, okay, but it is still a violation to not provide adequate food to a child under your care. That would be a criminal offense. That would
So
be
the-
abuse and neglect.
So what criminal statute are you alleging was violated here?
That would be neglect, which is no adequate parental care to feed, clothe, shelter, physical or mental injury, on out-of-home care. That's 215103A2 and 6.
But again, that's not a criminal statute.
Okay, but that sets a standard for abuse and neglect. That is neglect. The neglect is a criminal violation. Neglect of a
I understand that, but in order to succeed on one of these claims, you have to show a specific criminal statute that was violated here. And I'm not sure that I see there's the child endangerment statute, but the standard is slightly different for that.
Well, Your Honor, I think that if a neglect of a child is a criminally enforceable offense. I don't know how else to go about that.
Okay, so if you're looking at 291922A, which is criminalizing neglect of a child, that's still slightly different than the statute under the juvenile abuse dependency and neglect cases.
Well, it may be slightly different, but it still comes down to you have to provide adequate parental care to the children.
But it raises the standard of creating a substantial risk to the health or
Well,
safety of a
that's
child.
that's for abuse, but neglect is a lack of parental care. Abuse is a higher standard, yes, gives substantial risk of health and safety. Neglect is only adequate parental care.
So there would it be in a criminal situation, if somebody's getting charged criminally,
Yes.
it would just be the child is slightly hungry, or would we be looking at like the child is malnourished?
Well, no, I don't think it's either one of those necessarily be on the spectrum. Adequate parental care would be a matter of, the circumstances in that particular case. And in this case, we prevent all of this evidence, Gentry, Asher, Brandy, the Shamel Parker, and Ariana Weaver all saying that there was lack of food, and which would be a criminal violation. And so, I mean, there's food, yes, and then, and this, there's also lack of toiletries, lack of toilet paper. This also would be a violation of, in Ohio Revised Code 2151011B1, says you have to have adequate care for the children. And then the Ohio Administrative Code 51012919F says you have to have personal toiletries. And then the evidence here was that Gentry is saying you're out of toilet paper, and the supervisor is saying that there's you go bankrupt providing toilet paper. Shamel Parker, Carly Asher, Ariana Weaver all testified in their affidavits about the lack of toilet paper. And Ariana Weaver, she said specifically there was not adequate care as far as hygiene items. And lack of clothes, it's another item. This was all testified to by Brandy Oldham, the other residents, Shamel Parker, that the clothes were not clean, and that's something that's required to provide clean clothes. The bed bugs, that's supported by case law.
Could I'm going to focus you in on something else. I'd like for you to address the allegations of intimidation. What evidence exactly did you provide to show intimidation?
Okay. One is that every time my client complained about any of these issues, the food, toilet paper, clothes, bed bugs, the sex talk, every time that she complained about this, they said she was a liar, they said the children were liars, and it's just not true. That's one thing.
Okay, but it seems to me that that's denying culpability, correct?
Well, I think it's more than that, because if the owner of the facility is telling the employee that this is a lie and that they are a liar, then that puts them on a lower scale. It says that you're not to be believed, and that if you take some action on this, you're going to face the fact that I'm going to call you a liar. Now, that goes directly to the Simpson case, which was witness intimidation. In that case, the person who was potentially guilty, you said, there are consequences for lying. Your conduct will be resisted, and that sort of thing. And in this case, it was more direct because they consistently called not only my client a liar, but they also called the children liars. Now, the other thing...
Did they threaten consequences?
Pardon me?
Did they threaten consequences in this case?
Yes. I think it was more than a threat. It was an active purpose, an active pattern of consequences. The other two employees, Shamel Parker and Brandy Oldham, who also complained about all of these circumstances, they got fired after they complained, and when they got fired, they were told, or at least during the time of the complaints, they were told that don't take these complaints out, deal with us first. And then they got fired when they complained to the authorities. And there's also Carrie Doyle, one of the parents, or the aunt of one of the residents. She complained about all these same issues. And And then the owners of the facility screamed at her, said, "Do not go out. Take your things to us. Don't complain to the outside authorities." And it was a screaming match between them on the telephone. So you have all of these circumstances that show that that their consequences would be that you would get fired. And that's exactly what happened to my client when she took in the issue of the sex talk to the owners of the facility and said, you know, she's talking about, you know, how big her husband's penis is. She's talking about positions with the children, sexual positions with the children, and so on. And it's this abusive sex talk with the kids, and it's the same thing. The owner said, "This is false. You're a liar. The children are lying, and you're fired." So the whole pattern of circumstances lead to these negative consequences. So,
If you would like to reserve time,
yeah,
your
5
time
minutes.
is, yes.
That's it, okay.
Good morning. May it please the court, my name is Ted Capitas here on behalf of appellees Silver Linings, Shantia Gaines, and Chandra Davis. I'm quite sure this is the first time this court has ever faced claims of civil witness intimidation or civil obstruction of justice. Based on, I think, both sides' research, these claims have never before been brought in Ohio. I appreciate Judge Krause, or Judge Bach, you touching on whether there's criminality here based on the allegations of what was going on at these homes, because frankly, I think I would have to turn myself in. My kids have complained about being hungry. They've never had bed bugs, but we have had head lice in my house. You know, we've run out of toilet paper and our washing machine has broken down. Those things occur. As the trial court properly concluded, there was nothing here that rose to a criminal level of abuse and neglect of children. Even if there were, we don't have the crimes of either witness intimidation or obstruction of justice.
Before you go on, with obstruction of justice, and I meant to ask your opposing counsel this as well, you said in your brief that the victim of obstruction of justice is the state rather than whoever else.
Correct.
Do you have case law for that?
I think we did cite something in our brief. Offhand, I honestly can't recite it to you, but I believe we did have a citation in our brief. And I think it also goes just logically that if there is a victim of obstruction of justice, we know it's not Ms. Gentry. She's not the victim of obstruction of justice. And as to that claim, there was nothing that my clients did to obstruct justice. Her claim is that her employment was terminated, and that somehow prevented her from reporting abuse and neglect to JFS.
There still has to be an underlying crime.
There still has to be an underlying crime.
That's
yes.
what this all comes down to, is whether the allegations rise to the level of a crime.
If you're talking about abuse and neglect rising to the level of a crime?
I mean, for obstruction, don't you have to have an underlying crime that you're obstructing?
Yeah, presumably Ms. Gentry is saying the underlying crime is abuse and neglect.
Right.
And I'm with you here. It is tough to get one's mind around these claims, but I think I understand it to be the underlying crime is abuse and neglect, and that they're saying that Silver Linings obstructed justice by firing Ms. Gentry. I don't know how that possibly obstructs justice in any way. I think it would create a whole new line of wrongful discharge claims in Ohio, but I don't know how it obstructs her. She was a mandatory reporter. She had a legal obligation. If she even suspected abuse or neglect, she had a legal obligation under the statute.
Isn't that a different issue, though? I mean, whether at the time she met her duty to report, does that necessarily mean that there was no crime?
It certainly means that she didn't believe there was a crime. And even regardless of whether there was or was not a crime, even if there was, and there wasn't, but even if there was, how does firing her obstruct justice? It makes her no less likely to report abuse and neglect than before she got fired. In fact, it probably makes it more likely that she'll report because she's no longer beholden to silver linings for her employment. So I'm baffled as to how someone being terminated from their at-will job could possibly obstruct justice, could possibly prevent her from reporting abuse and neglect. And, you know, the person who investigated this, Mr. Gall, who found that there was no abuse and neglect, he knew who the people were. He had the names of everybody who worked at Silver Linings, and he could have easily contacted them. There's no evidence that my client ever did anything to stop him from contacting them, did anything to conceal who these people were. There's nothing here that prevented anything from being investigated. If I may go back to witness intimidation, Judge Krause, I think you mentioned the phrase, did they threaten consequences? And that's the essence of this. If we look at each thing that Gentry alleges constitutes witness intimidation, she said she was called a liar. I think, Judge Bach, you indicated that's just, that's denial of culpability. Exactly. Now, if someone says, hey, you stole those headphones, I saw you, and I say, no, I didn't, I think you're a liar. That's not witness intimidation. If I instead would have said, hey, I don't know what you think you saw, but if you go saying anything to anybody, I'm going to disclose to your spouse you're having an affair. Okay, maybe that gets there, but we don't have that here. There is no, at any point, any threat of adverse consequence for being a witness.
What about the argument that there were other people that were fired for the same kind of thing?
There were 2 people that were fired. Shamel Parker was fired 5 minutes before my client was fired, according to them. It was the same day, they walked in successively. So that's not possible. The other person was Brandy, and she was fired months before. And in their own brief, they point out she was fired after she made some complaint about not being reimbursed for expenses. We knew it was months prior that she had supposedly gone to JFS. And as their brief acknowledges, all that Silver Linings did is say, hey, look, if you're going to go to JFS, tell us too. We need to know what's going on here.
Well, couldn't that implicitly be seen as a threat?
That's awful attenuated to say that the termination of another employee months before for a different reason, for an expense argument issue, just because that employee happened to complain, does not mean that Ms. Gentry is intimidated from being a witness. There's no threat of consequence to her. No one ever said, hey, your job depends on that. Had Silver Linings said to Ms. Gentry, hey, you saw what happened to Brandy. That's going to happen to you if you say anything. Okay, maybe
Does it have to be that explicit?
there has to be some connection here. I think we're grasping at straws to reach back in time many months and say, oh, well, you could have inferred, maybe? There has to be, witness intimidation requires specifically intimidating a witness based on them being a witness. There was no investigation at that time. It's so attenuated as to rise to the level of witness intimidation. It's a real stretch to see how that gets there. Otherwise, I don't know, you can't, it seems like every employment termination is going to be construed as witness intimidation somehow. She also claims that we said Silver Linings said bad things about her. Again, that does not approach anything remotely getting to witness intimidation. And appellant also argues their most significant evidence of witness intimidation is the fight that occurred between Ms. Gaines and Ms. Gaines' cousin, Brandy Oldham, the other employee we're talking about here. And that fight with a non-party occurred more than 18 months after Ms. Gentry had been fired, and more than 6 months after this lawsuit had been filed, with no investigation pending, long after Gentry had anything to do with Silver Linings. Now, this fight might show what this case is really about, which is a family squabble playing out in court, but it certainly does not show witness intimidation. There's no nexus. And maybe that goes back to the firing question, too. There has to be some nexus between the intimidating act and the threat of witness intimidation, the threat that something is going to be be carried out if you testify, if you serve as a witness. The court was right. The trial court was right. Nothing Ms. Gentry has alleged bears any resemblance to witness intimidation. I think we've touched on obstruction of justice. She is not the victim here, and as we discussed, the mandatory reporter statute requires that she would have said something even if she suspected abuse and neglect. She said nothing not during the year of her employment and not during the 3.5 years thereafter. No reports of abuse and neglect. Nothing that Silver Linings did could have gotten in the way of that. And finally, unjust enrichment. There's literally no evidence to support that Ms. Gentry spent a dime on behalf of Silver Linings. The only things that she submitted were bank statements that demonstrate that she went to, like all of us, Kroger and UDF and Dollar General. She herself could not recall a single item that she purchased for Silver Linings or how much it cost. She submitted bank statements for the first 9 months of her employment. She acknowledges in her deposition that the only things she spent money on for Silver Linings occurred during the last month of her employment, and she submitted no documentation to evidence that. That is all that I have. I'm happy to take any other questions.
Okay, thank you.
Your Honor, going to this issue of criminal statute and so on, I think maybe in my appeal brief, I wasn't able to get that precise citation in there because of the word limitations and so on, but the criminal penalties for abuse and neglect are 2919.22 E1 and 2. 2919.22 E1 and 2 are the penalties for abuse and neglect. Now, the issues of obstruction, we talk about calling them a liar, things that happened to the other employees who complained, and there are additional facts there. One is that as soon as as Ms. Gentry complained about the problems of abuse and neglect, the owners of the facility started their process of bad-mouthing her to the other co-workers and to the parents and to the other students. And then there was this fight where one of Shantia came over to one of the witnesses' house, said, "Your mama's case is no good. You'll never win." Then she started an actual physical fight with the witness. So the witness is one of the people who complained, and during this fight, the person said, that was Brandy, said that, you're firing my mother because of this. Brandy was the daughter of Andina. You fired my mother because you complained, and you fired me because I complained, and then she started a fight. Now, you say, well, it was times, 18 months after the actual incident, but it was also during the litigation part of this case and before trial and before discovery was going on, and the case law is clear that threats to witnesses are evidence of guilt. And we cited those cases in my record, in the briefs. Now, the business about ODJFS, them not finding abuse and neglect, that is not correct. Scott Gall testified that he did not make a determination that there was no abuse and neglect. And that is, I cite that in my brief.
It was unsubstantiated?
He just didn't go that far. And That wasn't really what his purpose was, and he was there to resolve licensing issues, and he did not make a finding of no abuse and neglect. And the only way that would have any impact in this case would be if this was a res judicata collateral estoppel issue.
Those findings would be under the administrative regulations, not under the criminal.
Well, if they were, they would not be binding in this case.
Correct.
Yeah, and
Right.
but there was no finding of no abuse.
And
neglect.
again, the statute that you are referring to, 2919.22, that's
let me
the
get that.
criminal statute you're looking at, right?
Yes,
And it does require a substantial risk to the health or safety of a child.
Okay, I think that refers to both the circumstances of abuse and neglect. And abuse and neglect, both are defined as in abuse is lack of parental care. I mean, neglect is a lack of parental care, and abuse is the substantial risk. And we say, yes, there was substantial risk because, first of all,
So you agree that that the statute requires a substantial risk in order to rise to the neglect to rise to the level of a crime?
I think, my understanding is that the substantial risk is for abuse, and harm alone is enough for.
For a crime?
Yes,
Okay.
yeah. That's my understanding. And I think that we rise to that level. I mean, if it's a lack of food, it's a lack of clothes, it's bed bugs, and it's sex talk, and these things, the testimony is clear that this caused harm to the children, and that would be a crime. And,
You have about 30 seconds.
okay. Okay, so JFS, there was no finding that there was no abuse. And as far as the business about a liar, Simpson, the case tells us that just mentioning things about a lying would be enough to be witness intimidation and unjust enrichment. The three prongs of this, there was a benefit. They know that she was buying stuff. They know that it was a benefit to the company, and they said that, yes, she should be repaid, and they had the documents, and they didn't produce the documents. So they can't hold the documents back.
Was there any motion to compel?
We had numerous issues, and I think there was just a denial that the documents existed.
Okay, thank
Yeah.
you. Okay, your time has expired.
All right, thank you.
Thank you. This case has now been submitted, and we will issue a timely decision. And that concludes our cases for today. Have a great day, everybody.